Hello everyone, my name is Spencer Eckstein. I'm the facilitator for this module, which is called Introduction to Contract Law for the Corteva Women in Agriculture program. Just by way of introduction, I am a lawyer by profession and I am an alumni of GIBS. I completed my MBA with this university and very proud to say so. I also wanted to let you know that I'm part of the agriculture industry. I am part of a farming enterprise that is not far from Mohale City. It is a 22-hectare farming estate making fresh produce, lettuce, tomatoes, cucumbers, etc. As you can see from this slide, we're a little past a startup phase. We're in full production at the moment. We have a range of products which are grown in open field or under roof in greenhouses. So have both feet in this industry and looking forward to sharing some ideas with you. Just by way of content, in terms of the agenda for this session, I have divided the course into a number of themes. The first is to look at the background and context of the law of contract, and then to hone in and focus quite in a lot of detail on what constitutes a valid contract, because that is critical. Some issues around terms and conditions, as well as managing risk, and then some concluding remarks. So how do we understand the history and the context of South African contract law? Well, contract law in general has a very long history. Well, as long as people have been interacting and trading and exchanging goods and services, there have been some form of contracts. In South Africa in particular, our history has been shaped by what is called canon law. Canon law is basically the law derived from predominantly the Catholic Church and its philosophy and ideology around contracts. For example, marriage is considered a sacred vow and a sacred contract. That has filtered through into our law. The Romans were not only great engineers, but also great lawyers. And Roman law had a system whereby you had a particular type of law for each type of contract. So if you had property law, you had property contracts. If you had laws relating to ships or maritime issues, then you had separate contracts for that, and so on. Then there were a bunch of philosophers and jurists who, during the Dutch Enlightenment as such, who studied Roman law, improved it, tried to generalize it from its very specific categories, and create general principles of contract, which is effectively what we inherited into South African law via South Africa's Dutch colonial history, but also our English colonial history. So obviously South African law has inherited various features and traits that we have in common with the English legal system, which has carried through particularly into our company law and also into our contract law. The last thing, which is quite important, is what we call case law and jurisprudence. So all contractual disputes, which eventually end up in court, get interpreted, lawyers litigate about them, and slowly the law evolves and grows based on what courts and judges decide are the appropriate principles for particular contracts. That body of legal knowledge becomes what we call jurisprudence, and that jurisprudence informs and is informed by our law of contract. The last issue is statute. So statute is the laws that are passed by Parliament which have a contractual implication. So, for example, the Constitution is a law passed by Parliament, and it has various contractual implications. So, for example, in our Bill of Rights, we have laws that refer to land and property ownership, to labor and labor laws, to health, to safety, etc. So those things affect how contracts are concluded, but also there's very specific individual pieces of legislation that affect how contracts are concluded. And there's a wide variety of those types of legislation. So what is a contract and how do we define it? So contracts permeate every aspect of our daily and commercial lives, whether you go to the local garage to fill your car with petrol, or go to a store to buy airtime, or if you went to Woolies to buy clothing or food or whatever it is, all those things are regulated by contract. The car you drive, you probably have a car finance agreement with the bank. The house you live in probably has a mortgage bond with a particular bank. All of those things, whether you go to a doctor or a dentist, all of that relates to a contract. So contracts permeate our lives. So the question would then be, how do we define a contract? And the simplest and easiest non-technical definition which I can share with you is that a contract consists of two main pieces, an offer and an acceptance. So if you took, for example, a farming example, if somebody offered you a piece of land to be purchased by you or your family or your company for a certain price, and you were of the view that that was a good deal and you wanted to execute that deal, you'd have to conclude a contract. And in that instance, you would have an offer. Person A would offer you the land, and you would have to pay person A who offered you the land the purchase price, whatever that might be for that particular land. So at its most basic, at its most elemental level, it's an offer and an acceptance. So in law, an offer not any offer is a legal offer. So there are criteria which define whether or not a certain proposal or offer or written document constitutes a valid offer or not. And some of the criteria are that, for example, there has to be a declaration of will. In other words, there has to be some other action by which person A communicates to person B, whether verbally or in writing, that a certain thing is on offer. The second thing is that the offer has to be what in law is called firm. So in law, a firm offer means it is definitive and clear. In other words, the parties to the negotiation intend to create legal obligations between them, and the offer itself, so far as it has to be definitive and clear, can't simply be a general invitation to do business. So, for example, when you see an ad on TV which says X is selling product A and B for $9.99, that is not a legal offer. That is what's called an invitation to do business. It's an advertisement. So, and there are many examples where certain things don't really qualify as legal offers. So it's important that the offer must have a legal basis. The second thing is that the offer has to be what is called complete. So in legal terms, what that means is that the thing that is being offered and what is being accepted must be known and must be ascertainable, and there should be minimal room for error or misunderstanding. So in other words, when I'm buying a Porsche, there can be no confusion or misunderstanding to say that I'm buying a Volkswagen. It is a Porsche, not a Volkswagen. The other thing is that the offer has to be aimed at a particular person or party. In other words, the offer must be knowable to that person. That person must know that the offer is being made to them, and that there is some basis for that person to respond to the offer. So the offer of itself must also be capable of being accepted. So, for example, the offer must remain open. Often offers are time bound. It will say you're entitled to accept the offer, and the offer is open for 24 hours or 5 days or 10 days, whatever the case may be. And that offer must still be open to acceptance at the time and date when you accept it. It can't have been revoked or cancelled, or the person who made the offer should not be dead, for example, because then the offer is no longer valid. It lapses. It's also important to realize that when you change the offer in any way, effectively you are making a counter, and then the basis of the contract changes. In other words, if I say I would like to pay or I would like to buy a certain house, and the contract states that it is subject to a deposit of 10%, and I scratch out 10% and I put 7%, effectively I am rejecting the original offer and I'm making a counter offer for the other party to accept. If they accept 7% as opposed to 10%, then we have a deal. But if they don't, then the parties are not contracting on the same basis. In order for any contract to come into existence, one of the requirements is that the parties to the contract must have what is called contractual capacity. Now, contractual capacity means that you as a juristic, i.e. a company, a non-natural person, or a natural person, are empowered and have the legal capability of entering the contract and understanding the legal and other implications of entering that contract. So typically, you will see on a contract, it will say, there's a signature clause and it will say duly authorized. That is critical. So people in companies cannot simply sign contracts. They must have the relevant authority or delegated power in order for them to sign contracts. Same as somebody who's under the influence, their capacity is impaired and they can't properly conclude a valid contract. So having the relevant authority and legal capacity to conclude a contract is critical to the formation of that contract. Often people ask, are there formalities that are required in order for you to conclude a contract? So the general rule is that normally you do not need to have a range of formalities which must be complied with in order to conclude a contract. So with every rule, there are exceptions. It's also true that not all contracts need to be in writing. They can be verbally concluded. So verbal contracts are binding. It's just much harder to prove as a matter of evidence. However, there are specific pieces of legislation and specific types of contract which require that the agreement be reduced to writing and that they must be signed by the parties involved. And some examples of this include sale of property and land. These have to be in writing. Your antenuptial contract, if you are married or planning to get married, has to be signed and notarized. Agreements of suretyship. So, a situation where person A agrees to stand surety for person B. So what that means is, in the event that person B defaults on the repayment of their loan or some other performance criteria, then person A will step into their shoes and perform what is required or pay what is required. So suretyships are a serious contract and have to be signed. Other types of contracts which have to be signed are credit agreements. And so you'll notice most, in fact all, banking contracts need to be signed and are documented. So if you're opening a bank account, if you have a credit account or a credit card that you apply for, or an overdraft, or a bond, or car finance, etc. All of those are credit agreements and require written contracts. One of the more important things to understand about contracts is that contracts have a certain logic. They're constructed in a particular way. And if you understand what the logic is behind contracts, they become much easier to navigate. So the first thing to understand about a contract is that you always have to check who are the parties to the contract. So for example, I work for a company called Quasi, but there's also in the industry a company called eQuasi. And it has happened, for example, that a contract was issued in their name, not in our name, and they were paid and we were not paid. So you can make a major mistake if the parties are not correctly identified in the agreement. And typically this means you have to put people's full names, their ID numbers, their residential addresses, or if it's a company, the registered company number, the registered company address, and who the authorized representative is of the company who will be dealing with that contract. The next important thing is what. So what is the subject matter of the contract? Is it goods, services, scope of work, etc., which defines what must be delivered. And typically this might appear in a purchase order, in an invoice, in a statement, etc., but there has to be agreement on what is to be delivered. The next thing is there are often standards that are applicable to what has to be delivered. So in other words, the product has a specific specification, or the service that is being delivered will also have some other type of specification. That will have to be defined. Or if it's simply delivery of a service, it also might mean that the service to be delivered has to be delivered according to a particular standard. In normal contractual situations, this means that there is what is called a duty of care, which means that whatever service or goods have to be delivered, those goods have to be delivered or produced in a way that is standard and according to industry norms and standards and reasonable practice prevailing at the time. So we know who, we know what. So then the issue is when. When does the contract start? When does it finish? Is time of the essence within the context of that contract? What is its duration? When do you have to deliver what? That's critical. The next thing is about how. So what's the modality of the contract? How are the goods or services to be delivered? And what constitutes delivery? Is delivery when I put it on your doorstep or your farm gate or in front of your warehouse, or when it's still on the truck or on the bakkie, whatever the case may be. So you have to specify what constitutes delivery. You also have to define where the relevant services have to be delivered. Often there is a rationale for a particular type of contract, and that will explain the why. So is it a sale? Is it a lease? Is it an insurance contract? Is it delivery of vegetables or phosphate or agricultural implements? Is it a solar system for or generator, etc. The next and probably the most important is what I call show me the money. So you have to understand in terms of the contract, what's the purchase price, how will it be paid, when will it be paid, and what happens if you don't get paid. Those things are critical to the success of the transaction. The last thing is to understand what could go wrong. And often you have to develop contracts on the basis of what's the worst possible scenario that you are catering for, and to manage and avoid that particular risk from materializing. In this instance, often there have to be rights, remedies, and protections for instances where things do go wrong. So the contract may have penalties. It might be that the contract itself is suspended. It might be that it's a full breach of the contract, in which case, one or other party is entitled to cancel the contract or claim specific performance or damages. There are also instances where you would have to invoke a dispute resolution procedure, or it might be force majeure. We'll talk a bit more about force majeure later. Lastly, the most important thing is to understand that a contract is both a sword and a shield. It can help you defend yourself as a shield, or it can help you to enforce your rights when you need them. So now we are at the important point of what constitutes a valid contract. So in law, there has to be what is called consensus ad idem. That means there must be a quote-unquote meeting of the minds. The parties involved must effectively agree on what I call the essentialia, the things that are the most important ingredients of the contract. The second thing is that the parties must have intended to seriously create obligations which can be enforced. The parties also must have the capacity to contract. The agreement itself has to be certain and must have definite terms. The relevant formalities, if there are formalities, have to be observed and be in place. This seems like an obvious requirement that the contract must be lawful, but for example, if you contract a hitman or hitmen to assassinate somebody, and they pull out and don't do what they contracted to do, quote unquote, then you can't sue them for breach of contract, because the contract was not lawful in the first place. It would be unlawful on two grounds at least. One is what's called public policy, so it would be against public morality. And secondly, it's for an illegal purpose. The purpose was to kill another person. So contracts have to be for lawful purpose, and then ultimately the contractual obligations must be capable of performance. So for example, if I sell you title to a particular plot on the moon, there is no way that you can grant me the title to that piece of terrain on the moon. Well, not now, given the current technology anyhow. So there's no possibility of performance. One of the important things to understand about contracts is that it's a set of rights and obligations. The rights which you, for example, as a buyer, are entitled to have, versus the obligations which, for example, a seller might have, which, for example, would be to deliver a particular item. So it's important to remember that the actual agreement, the written document, the text of the agreement, is the founding piece of evidence relating to what the parties agreed. So generally, courts do not make contracts for parties, and it will not break contracts for parties. It's also important to remember that it is no defense in court to say you did not know, or you did not read, or you weren't aware that a certain provision existed. You are presumed to have read, and you are presumed to have understood, and you are also presumed to have understood the risk. So in law, there's something called caveat emptor, which means the buyer must beware. So the risk is on the buyer to make sure that whatever it is that they're buying is of the right quality, standard, and quantity, for example. Now, the courts respect what is called freedom of contract. In other words, you as a sovereign individual can contract in any way you wish, provided it's for a legal purpose, and the courts will recognize what is called the sanctity of contract. In other words, the courts favor interpretations which leave contracts in place and which require parties to do what they said they would do and deliver what they promised to deliver. So that is critical. The only time that the court is likely to undo a contract is if it is in the public, if for public policy reasons it's suitable to do so, or if there's a statutory reason for doing so, for example, the Constitution. It's also important to remember when the terms are different from what are called conditions. Terms are the essential parts of a contract and are effectively the obligations. The conditions are events which are time-based and uncertain, which must come into effect at a future date in order for the contract to be fulfilled. So, for example, if you bought a house or a property, you would say that the contract is subject to you obtaining a bond. If you do not obtain a bond, then the deal will fall through. So, for example, there also is a school of thought which says there's no contract until the condition is fulfilled, and there's a different school of thought which says there is a contract the minute you agree. This is simply about whether future obligation is met, i.e. a suspensive condition is fulfilled. Very important to understand to what standard of performance you as a farmer or supplier are being held to. Never ever agree to a contract which says you must deliver best of breed, world class, best practice, etc. None of that's applicable, and you don't have to agree to it, and you shouldn't be agreeing to it. Because ultimately the only thing that's relevant is what's called the reasonable test. The reasonableness test is whether a reasonable farmer in the same circumstances would deliver what you deliver. So that's important. I want to also just share with you a particular text from a contract to explain and show you how companies might stipulate that particular clause. The next point I want to make is about terminations. So often in the context of employment, you will hear somebody says they have handed in their resignation and they're waiting for the company to accept their resignation. Now, resignation is a termination of an employment contract, and it's a unilateral act. It doesn't require consent. So if you terminate the contract, you terminate the contract. However, most major contracts will have some or other process by which you can cancel, and you have to follow those procedures meticulously. If it says you must give 30 days notice, you must give 30 days notice. If you do not, the contract is not terminated, you haven't given proper notice, and effectively it means the contract continues. So be very careful about termination. How do we understand this concept of a breach of contract? So a breach of contract is a substantive failure by a defaulting partner to, or defaulting party to do or deliver something of material importance to the other party. And typically that party suffers some or other form of harm or loss. So that, for example, is one type of breach. And the emphasis is more on the fact that some or other material obligation has not been performed. The next important concept to understand is the question of liability. So when a contract is entered into, you have certain obligations. If those obligations are broken, you incur liability. In other words, there's a legal consequence that follows non-delivery or non-performance, and you would have to then either remedy that performance, or the contract will be cancelled and you will be liable for damages going forward. I also want to make the point that you have to distinguish between different types of damages. For the purpose of this discussion, we will only focus on contractual damages. So it's only the damage that arises from the contract, nothing else. There's a different branch of law, which is called delict, which deals with both your direct losses as well as your consequential losses. And that is a completely different field and a completely different set of criteria that would be applicable to that type of damages. So generally, the idea is that in your contract, you have to figure out a way to limit liability, to cap it, and to provide for what is called an indemnity. An indemnity is something which really allows you to shield yourself from particular claims, either from the client or from other third parties. It's also possible to manage that risk by obtaining insurance, and you can obtain insurance for just about anything to cover just about any risk. So whether it's risk of flooding or lack of power or crop failure or fuel shortages or logistical issues, you can get insurance for any of that. This is a particular example from an actual contract, which is intended to give you a sense of how a limitation of liability clause would read. An indemnity is then a very important contractual concept to understand. And basically what it means is it's a particular term that allows you to transfer risk and to protect yourself and shield yourself against potential liability. So in this instance, the contractor indemnifies and holds the company, its directors, managers, agents, employees, etc., harmless against all loss, and to be suffered by them and in connection with the contract, and including, in this instance, environmental damage, statutory failures, injury, death, damage, etc. So what you want with this type of indemnity is that it should be what's called a mutual indemnity. So in other words, you indemnify the other party and the other party indemnifies you. And in that way, you can manage contractual risk. One of the important concepts that I want to share with you is the question of force majeure. So force majeure sometimes is referred to as acts of God, but in legal and contractual terms, effectively what it means is a circumstance or situation which is beyond your reasonable control and which makes performance impossible on a temporary basis. So usually the contract will prescribe a definition. It will say what constitutes a force majeure, and then it will stipulate a procedure. What do you need to do if and when there is a force majeure? So, for example, you might have a strike on your farm, and you're not able to deliver. So you may be able to then declare force majeure, but as soon as the strike is over, you would then be able to restore supply and delivery. This brings us to the question of risks and major challenges from a contractual perspective in regard to agricultural projects. So one of the obvious ones is concerning land and access to land. Related to that is the issue of land ownership, whether by way of a lease or sale. Getting funding and access to capital is always critical and difficult, and the contracts that go with that are complex. The other major problem for agricultural projects is securing an offtake agreement. So, for example, in our case, we do not supply directly to a distributor. We supply to another farm that is larger than us, and they then supply to Food Lovers Market, etc. So we don't supply directly to the end user. We go through an intermediary. So that's one particular way of solving the problem. But not having a secure offtake agreement is a huge problem for agricultural businesses. The last is around execution risks. And execution risks can take a multitude of forms. Often they're the difference between being a startup and getting to a steady state of production. So how do you deal with this? So you have to understand the risks individually and to address each major risk from the perspective of you either want to avoid that risk, you want to manage or mitigate it, or you want to transfer that risk. And then you have to use the contract to be able to do that. It means you have to understand contracts quite well. You might need lawyers to help you or other people to assist you to decode the agreements and to understand what you want to achieve with them. Often, one of the major issues is about the actual terms and conditions of the agreements. You might go to an off-taker like a Spar or Woolworths or Pick n Pay, etc., and they are simply going to give you their standard terms and conditions. And you're going to find it very challenging to try and amend those standard terms and conditions because they've spent a lot of time and a lot of lawyers' time getting to those standard terms and conditions. So not having a proper balance of power between you as a producer and suppliers or sellers or off-takers is a major problem. The next major issue is payment terms. So you have to pay attention to the contract very carefully so that you are paid timeously to avoid cash flow problems. And this really relates to the next risk, which is really about non-delivery, either by you as the supplier because of issues related to input constraints or the supply of end products or outputs. And so really those are logistic type risks and execution risks. The last, it would be the risks related to reputation or litigation, which you would have to avoid as far as possible. Thank you for your time and attention. That concludes the lecture. I hope you've enjoyed it and I hope that you've learned some new insights from it. I look forward to the online and live sessions in due course. Thank you very much.